Hello everyone, welcome to BYJU'S Exam Prep. I'm Nivedita Rajay and today we are going to discuss very important questions that might be there in your exam, MH-CET plus SLAT. So we have done a thorough analysis of all the last year question papers and based on that we have come to this conclusion कि ये सारे questions अगर आप revise कर लें तो आपकी preparation में काफ़ी development आएगा. Right, so good evening everyone. How are you all? Welcome and hello. Yes. Now, before we proceed, you should know that BYJU'S is distributing up to 90% scholarship. All you have to do is just register and then appear for a test that we are going to conduct on, actually it is tomorrow, right? It's 4th today. So it is tomorrow at 11 p.m. If you have not registered, you can still do it. In fact, you can do it till 10:55 tomorrow. So you register it, you attend the test, and if you are able to go over the threshold, you will be given an amazing scholarship at the comprehensive courses that BYJU'S is launching, right? Okay. So let's start. This is the question. Question number 1. Where both the parties to an agreement are under a mistake as to a matter of fact essential to the agreement is void. Basically, a bilateral mistake makes an agreement void, especially when that mistake is essential to the entire spirit of the contract. If it is something which is ancillary, does not really matter, then the agreement does not get affected. लेकिन अगर कुछ ऐसा फैक्ट है जिसके बेसिस पे या जो अग्रीमेंट का बेसिस है उसी पर मिस्टेक है तो फिर अग्रीमेंट वॉइड हो जाता है. Right, so the facts are Ashish agrees to buy from Avantika a certain horse. Turns out that the horse was dead at the time of the bargain, though neither party was aware of the fact. Validity क्या होगी agreement की? Okay, Vaishnavi says it will be void. These are the options. Agreement is valid, agreement is void, agreement is valid, agreement is voidable. Good evening, good evening. Yes, so what do you think? Okay, my screen is in the wrong direction, isn't it? Can you give me a sec? Better? Yes. B is absolutely void. The agreement is void. Why? Because parties to the agreement were under mistake of fact. Yes, B is absolutely right. Moving on. Question number 2. Agreements, the meaning of which is not certain, capable of being made certain, are void. Basically, unmeaning agreements or agreements which have a certain which have an element of ambiguity, जिनका मीनिंग निकाल नहीं पाओगे तुम, तो उस तरह के agreements भी void होते हैं. Nitin purchased a bike from Nikhil and promised that if the bike was lucky to him, he would give rupees 1000 more or he would purchase another bike from Nikhil. Is there a valid contract between Nitin and Nikhil? Yes. मेरे बैकग्राउंड से तुम्हें क्या करना है? क्वेश्चन पे ध्यान दो बच्चे. Right, so there's a valid contract. Nikhil will be liable if the bike didn't prove lucky. There's a valid contract. Nikhil will not be liable. There is no valid contract. As the terms are vague, contract is voidable at the option of Nitin. Give me an option. Give me an option. We have A, B, C, D. Vaishnavi says it's C. Who else says it's C? Kanishk also says it's C. Okay, okay. Yes, go on, go on. बढ़ते जाओ, बढ़ते जाओ. It is C. Yeah, you are absolutely right. The meaning is certain. It's uncertain. The bike proves to be lucky. How does a bike prove to be lucky? मतलब ही क्या है इस चीज का कि अगर तुम्हारी बाइक लकी हुई तो मैं तुम्हें 1000 रुपए एक्स्ट्रा दूंगा. मतलब लकी मतलब कैसे होगी लकी कि अगर तुम कहीं जा रहे हो और किसी ट्रेजर चेस्ट से टकरा गई या चलते चलते तुम्हारी बाइक के नीचे कोई ट्रेजर मैप आ गया. इज दैट व्हाट यू आर सेइंग? भाई कैसे हो सकती है वो लकी? या तो तुम एक्सप्लेन करो कि अगर इस तरह से लकी हुई तो मैं तुम्हें एक्स्ट्रा पैसे दूंगा. अब इसका कोई मीनिंग ही नहीं निकल कर आ रहा है तो ये अग्रीमेंट वैलिड नहीं होगा. राइट? सी इज करेक्ट. Question number 3. In order to convert a proposal into a promise, the acceptance must be absolute and unqualified. You need to remember this theory, you need to remember this principle, it's important. ठीक है, proposal, acceptance तभी कंक्लूड होता है जब एक्सेप्टेंस में कोई मोल भाव या किसी भी तरह का हैगल हैसल ना हो. ओके. Now, Rahul made a proposal to sell his house to Vipin for 50 lakhs. Vipin agreed to buy it for 48 lakhs. Rahul sold the house to Praveen for 49 lakhs. Vipin sues Rahul for damages. You're attending for the very first time. Miriam, good evening. I welcome you to this session. We are practicing few questions that I think might be there in the MH-CET exam. So you can attend the session and you can figure out कि किस तरह के questions आएंगे if you are taking the exam, or you can also get the idea of how the session is conducted, right? Welcome. Yes, answer people. Vipin is entitled to receive damages. Vipin can proceed against Vipin. Vipin will only get the difference of 1 lakh. Vipin will not get any damages from Rahul. So Vaishnavi again is the first to answer. Kanishk follows. Mariam has also answered. Amazing, and you absolutely are right. Vaishnavi, Kanishk, Shamit, Mariam and Mala, D is absolutely right. Yes, he will not get damages. He haggled. Right. So proposal plus acceptance becomes an agreement. Anything other than acceptance means it is not an agreement. So proposal plus counter proposal will not make it an agreement. 50 लाख का बेचूंगा, नहीं मैं तो 48 का खरीदूंगा, तो ये प्रपोजल का एक्सेप्टेंस नहीं है, ये प्रपोजल के ऊपर एक नया प्रपोजल है और इससे अग्रीमेंट नहीं बनेगा. राइट. डी इज करेक्ट. वेरी गुड. Yes, Mala, it is. Fortunately, it is. Question number 4. Agreements by way of wager are void. Okay. Now, facts are Raja placed a bet with Neeraj that he'll pay him rupees 10,000 if England wins the match. And if Australia wins, Neeraj is required Raja the same amount of money. England wins the match. Raja refuses to pay. Which of the following statement is the most appropriate in relation to the legal principle stated above? Okay, so we have a problem. Yes, so these are the options. What would it be? Neeraj can file a suit for recovery. The agreement between Raja and Neeraj is valid. Agreement between Raja and Neeraj is void. Raja and Neeraj ka agreement voidable at the instance of Neeraj. What do you think? It's pretty simple. Pretty straightforward if you ask me, nahin? I'm sorry. This was the charger. If you could see the wire. It is C. Absolutely. It's a wagering agreement or wagering agreement. Indian Contract Act allow नहीं करता. C सही है. Question number 5. Agreement not enforceable by law is said to be agreement which is not enforceable. Yes, very good. It's C. It is said to be void. Good. Which, when a proposal or acceptance is made otherwise than in words, the proposal is said to be. Words के अलावा अगर acceptance या proposal किया जाता है तो उस तरह के promise को क्या कहते हैं? Express, implied, tacit, none of the above. The correct answer is yes. Very good, Mala. It is B. It is implied. Right. For example, if A proposes to B that I'll buy your house if you repair your balcony, the very next day B starts the repair work in the balcony. Now in an implied manner he has accepted the proposal, इसीलिए उसने balcony का repair work शुरू करवा दिया है. इस तरह के promises को implied promises कहते हैं कि आपने बोला वगैरह कुछ नहीं, लेकिन आपके action से पता चल रहा है that you're in it. Okay. Yes. Before we move forward, you should know that we have launched a comprehensive course for CLAT 24. Now, the course or the features that make it comprehensive is that it is not just a course for CLAT. It caters to all other examinations. All the other law entrance tests are taken care of just by this single course. You name it, ALET, SLAT, BHU, AMU, which is now QSET, JAMIA, MH-CET, जो भी एग्जाम लॉ एंट्रेंस का जो इम्पोर्टेंट है, सिग्निफिकेंट है, जिसके लिए आप अपेयर करेंगे, उन सब की तैयारी आपको ये एक अकेला कोर्स करवा देता है. Right, it has more than 600 hours of sessions recorded plus live. We give you about 35 tests for CLAT and other mock tests, which keep on changing once you're done with them. Then we have a monthly e-magazine for current affairs. It is called CLAT Ignite. It is created keeping you in mind. तो वो आपके ही हिसाब से और आपके ही सिलेबस को ध्यान में रख के बनाई जाती है. यस, मरियम, MH-CET के लिए भी मॉक्स अवेलेबल हैं. सेक्शनल टेस्ट मॉक्स सब अवेलेबल हैं. वी हैव अ रिपोजिटरी ऑफ मोर देन 10,000 क्वेश्चंस. उसमें सब क्वेश्चंस हैं. क्लैट भी है, MH-CET भी है, एलेट भी है, सब है. ठीक है. Or the best part of the entire syllabus or the content that we give to you is that it is curated by people who are NLU alumni themselves. So they exactly know what to study क्योंकि उन्होंने भी वही एग्जाम दिया है, तो वो जानते हैं तुम्हें क्या पढ़ने की ज़रूरत है. Okay, and in case of any query, in case of anything that you need to know, you need to call us at this number and people or our counselors will guide you. Okay, B was correct. Now this is the principle. Read it and give me 1 second. Just 1 second. Yes, I'm sorry. Huh. So every agreement by which anyone is restrained from exercising a lawful profession, trade or business of any kind is to that extent is void. Which means that any agreement which restrains somebody was from carrying out a lawful profession, trade or business is void. So an agreement which violates Article 19 is void. Simple, in simple words, right? Good evening. Of course. So company X entered into a contract with company Y to bottle soft drinks. तुम question पढ़ चुके होगे. Let's look at the options. Contract is void since it restrains the lawful right of the company X to engage in business. Contract is voidable at the instance of company X as it restrains the lawful right of the company X to engage in business. Is valid, is void since the competitors of company Y are not party to the contract. I'm good, Alina. Thank you so much. How have you been? The answer is yes, it is A. Very good, Vaishnavi and Kanishk and everybody else who's saying A. Yes, Sharad, Shamit, it is A. Contract void है क्योंकि वो एक कंपनी को lawful business में engage होने से रोक रहा है. Good. Now, which of the following is not an essential ingredient for the formation of contract? Contract को बनाने के लिए इनमें से कौन सा element essential नहीं है? Property, acceptance, consideration, proposal. Very easy, isn't it? Property, acceptance, consideration, proposal. Yes. So Alina is the first to answer here, I guess. No? Yes, it is A. Property. Property से contract का कोई लेना देना नहीं जब तक property contract का subject matter ना हो. Property के अलावा भी और subject matters पर भी contracts बन सकते हैं. तो it is not essential. However, acceptance is definitely an inherent part of a contract. That's how a contract begins. Consideration makes an agreement absolutely valid and gives it a force of law. And proposal is something with which an agreement begins, right? यहीं से agreement होने की शुरुआत होती है, तो ये तो बिल्कुल ही important है. A is absolutely right. Moving on. A contract implied by law is known as एक ऐसा contract जिसको लॉ अज्यूम करता है कि कॉन्ट्रैक्ट होगा. मतलब पार्टीज इस कॉन्ट्रैक्ट में एंटर नहीं हुई हैं, लेकिन लॉ ने फिर भी एक फिक्शनल कॉन्ट्रैक्ट पार्टीज के बीच में क्रिएट कर दिया है. ठीक है, तो किस तरह का कॉन्ट्रैक्ट होता है? कंटिंजेंट, वेजरिंग, क्वाज़ी या क्वांटम? वेटिंग. Very good. Yes, Sharad, it is C. It's a quasi contract. So there are relationships in which people do not want to engage in a contractual relationship, but then due to the nature of the situation, so that nobody suffers a loss and for the reason of equity, ताकि justice हो सके, किसी पार्टी को unnecessary loss bear ना करना पड़े, वहाँ पे contract act एक fictional contract create करता है ताकि unnecessary loss और अनटाइटल्ड बेनिफिट्स को रोका जा सके, राइट? यस, क्वाज़ी कॉन्ट्रैक्ट. मूविंग ऑन. A contract requires a proposal and an acceptance of the proposal. It is necessary to make a binding contract, not only that the proposal be accepted, but also that the acceptance is notified to the proposer, right? So A wanted his best friend B to buy his car. He thought of making a proposal to be at his birthday party. B could not attend the birthday party, so A offered to sell the car for rupees 2 lakhs by a letter. B accepted the proposal, did not inform A about the acceptance. As a result, A sold the car to C. Now B wants to file a suit against A for breach of contract. Decide. Anyone? Question. Sorry, मैं तो भूल गई कि options भी दिखाने. These are the options. A is liable for breach of contract because both offer and acceptance were complete. A is liable for breach of contract because B accepted his offer. A is liable for breach because he himself wanted to buy the car. A is not liable for breach of contract because B never notified his acceptance. What do you think it is? Yes, come on, come on. It's D. Very good. A is not liable for any kind of breach क्योंकि acceptance जब पहुंचा ही नहीं तो agreement ही नहीं बना. Agreement नहीं है तो breach कैसा? There is no contract to begin with, right? बाकी सारे options A को liable create declare कर रहे हैं तो वो इसलिए गलत हो जाते हैं क्योंकि A की liability है ही नहीं. A is not liable. There is no agreement, right? Now, question number 11. A contract obtained by misrepresentation is voidable at the option of the buyer. A leads B erroneously to believe that 500 mounds of indigo are made annually at A's factory. After this, B buys the factory, after which he comes to know that only 400 mounds of indigo have been made. Decide the validity. I cannot, these are questions in English. How do you want me to translate? जितेंद्र, the exam is in English और मराठी, तो या तो आप अंग्रेजी में देंगे या मराठी में देंगे. क्वेश्चंस ही इंग्लिश में तो मैं क्या करूं, है ना? पढ़ लिया सबने? Decide the validity. Is the agreement valid? Now the options are: the agreement is valid, agreement is void, agreement is voidable at the instance of A, agreement is voidable at the instance of B. कौन है पार्टी? The agreement is yes. So I have Sharad who has answered first. It is D. The agreement is voidable at the instance of B. It's B who was misrepresented, right? So if B wants, he can come out of the contract. He can get the contract declared void. Yes, D is absolutely right. Very good. Now there are two principles here. The rule of strict liability makes the defendant liable for accidental harms caused without any intention and negligence on his part. If the escape has been unforeseen and because of supernatural forces without any human intervention, the defense of the act of God can be pleaded. Our facts क्या हैं? A built 7 reservoirs in his land situated in a village of Mystic Falls. Okay, due to an unusual rain, the water from reservoir escaped and caused loss to the neighbors who filed a suit against A for strict liability. Assuming that the rain was unusual, which was never experienced in the village of Mystic Falls, decide A's liability. Yeah. MH-CET per se is not a difficult exam. If you have read the question papers, if you have analyzed them, you must have seen कि वो अपने आप में बहुत difficult exam नहीं है. और legal और GK relatively easy रहता है. It is the logic that plays the role. वो खेल बिगाड़ देता है. तो उसमें आपको ज़्यादा मेहनत करनी होती है. Okay. These are the facts. You already know about it. Facts पढ़ लिए ना सबने? चलो options देख लेते हैं. A is strictly liable for causing accidental harm to his neighbors. A is strictly liable because he brought a dangerous substance to his land. A is strictly liable because the dangerous substance escaped and caused loss. A is not strictly liable because the rain was unusual. बताइए. Is A strictly liable? Vaishnavi is absolutely right. It is D. A is not strictly liable. Act of God will apply. Right. So the rain is of unusual nature. It it's something that was not witnessed by people ever before. So obviously one could not foresee it or prevent the damage that it might have entailed. So the defense will apply and the liability won't stick. Yes, D is absolutely right. Moving on. Section 73 of the Indian Contract Act is based on Hobbs versus Howard, Sears versus Pickard, Hadley versus Baxendale, none of the above. मान के चलो ये क्वेश्चन हर पीसीएस जे के एग्जाम में आएगा. मतलब इफ यू आर एस्पायरिंग टू बिकम अ जज आफ्टर यू आर डन विद लॉ, तो आप इस क्वेश्चन को अभी से रट लें, क्योंकि ये क्वेश्चन 100% किसी ना किसी स्टेट के एग्जाम में पूछ ही लिया जाता है. इनफैक्ट ये यूपी में तो हमेशा ही पूछ लिया जाता है. इतना कुछ इंपॉर्टेंट है ये क्वेश्चन फॉर सम रीजन. Okay, so what is your answer? Everyone? No idea about this? This is C. इसे याद कर लो, ये MH-CET में पूछा जा चुका है. 73 basically stands for quantum of damages. So in a contract where the damages are not really mentioned, what should be the quantum? Like what is the parameter of awarding damages to a person? So foreseeability of damages और डैमेजेस का क्वांटम क्या होना चाहिए, फोर्सिबिलिटी को कितना फैक्टर करना चाहिए, मतलब जो डैमेज तुम्हें लग रहा था हो जाएगा उतना ही डैमेज तुम पे करोगे, या फिर उसके एडिशन में भी कुछ अगर हो गया तो वो भी तुम्हारी जिम्मेदारी. Right, so Hadley versus Baxendale is the landmark or the authority on this section. Remember it and always remember it. It will be asked in some judiciary exam as well. Okay. Question number 14. The law of contract is based on the principle laid down in which of the following Latin phrases? Bellum inter duos pacta sunt servanda, actio personalis moritur cum persona, consensus non concubitus facit matrimonium. My God, Harry Potter spells. I don't have a Bugatti. Okay. Consensus non concubitus. Okay, I'll tell you this one. It is B. Pacta sunt servanda. That is the core principle of any kind of contract law, whether it is national or international. Pacta sunt servanda के basis पर ही आता है. Contract binds everyone. So if it is a contract which is of national nature, like a domestic law, then it binds the parties. If it is international, it binds everyone. But it is based on the similar premise कि contract जिसके लिए किया जाता है, चाहे वो कोई और क्यों ना हो, सबको बांध देता है. B is absolutely right. Yes. Moving on, question number 15. An agency created under the Indian Contract Act is terminated by who? अगर एजेंसी को क्रिएट किया गया है तो उसे कौन टर्मिनेट कर सकता है, या वो किस तरह से टर्मिनेट हो सकती है? पैक्टा sunt servanda का मतलब है, word contract is derived from the word, wait, did I do it or नहीं, I was wrong. Pacta sunt servanda मतलब agreements or pacts have to be followed or they must be kept. That is what it literally means. Okay. So an agency created under the Indian Contract Act. Okay, all of the above, you're absolutely right. Principal can revoke the authority. Agent can renounce the business of the agency. If principal becomes a person of unsound mind, then also the agency is terminated. All of the above is absolutely correct. Very good. Moving on. Pledge is a contract of what? Is it a contract of guarantee? Is it a contract of bailment? Is it a contract of indemnity or agency? Yes. Alina says it's D. Pledge is a contract of guarantee. Are you absolutely sure? Anybody else who wishes to take a chance? It's a contract of bailment, guys. Okay, what exactly is pledging? Pledging means when you are basically keeping your movable items as a collateral. So, if, for example, you need an amount of money and you don't have it, so you ask that amount from somebody else. Now he needs to secure that loan. कि भाई in a situation where you are not able to pay, क्या वो लॉस सफर करेगा? नहीं, वो उसके बदले में तुमसे कुछ ले लेगा जिसकी इक्विवेलेंट वैल्यू है या फिर उससे थोड़ी ज्यादा है. तो इन एन इवेंट जहाँ पे तुम पे नहीं कर पा रहे हो, उस सामान को बेच के वो अपने लोन को रिकवर कर लेगा. और इस चीज को प्लेज कहते हैं. जब इसी एक्सरसाइज को हम एक इमूवेबल प्रॉपर्टी के साथ करते हैं तो उसे मॉर्टगेज कहा जाता है. राइट, सो that is pledging. So obviously you are giving an item to somebody for a particular purpose, and the purpose is to secure a loan. Or bailment bhi wahi hai, right? Somebody else has the possession of your property for a limited time or for a particular purpose. As soon as the purpose gets exhausted or the time gets complete, he needs to return your property. So it is bailment. Pledge is a contract of bailment. Right? When anyone uses his property in such a manner as to cause damages to others, he commits the wrongful act of private nuisance. Principle. Facts. Danish erected a brick grinding machine adjoining the premises of Param, a dentist. The dust from the machine spread in the nearby environment and eventually entered Param's clinic and caused inconvenience to Param and his patients. Param filed a suit against Danish. Now decide. I just told you, Mariam, when it is a movable, when it is an immovable item, we call it a mortgage. मैंने कहा तो था. Alina, Garvit, please stop disturbing my class, buddy. It's your private matter. If you know, there is a proximity where she can take a book and you could give her the book. Why don't you speak with her directly instead of asking me to convey your message? I'm not a messenger. पोस्टमैन मत बनाओ मुझे. अगर वो तुम्हें किताब दे सकती है तो फिजिकल प्रॉक्सिमिटी होगी, उससे मैसेज वगैरह कर दो यार. ठीक है. दीज आर द मैं तो पढ़ा ही नहीं. हाँ, तो विल परम बी लाइबल फॉर private nuisance? Param will not succeed, sorry, Danish, as Danish is carrying on a legal lawful business. Danish has fundamental right to carry on any kind of business. Param can claim damages as Danish's activity amounts to nuisance. Danish can claim compensation from Param as Param is trying to maliciously prosecute Danish. What do you think? It's pretty straightforward. You don't know? Okay, just ignore. Garvit, buddy, stop disturbing my class. Okay, it's a request or I'll be forced to take an action. I'll have to block you. Don't do that, please. Request. See, yes, it is a matter of private nuisance. Something as disturbing as a brick grinding machine can definitely cause a lot of disturbance. यार ये क्या तरीका है? तुम ऐसे क्लास में आके डिस्टर्ब नहीं कर सकते. प्लीज डोंट डू दैट इन एनी सेशन. दिस इज नॉट गुड. ठीक है, सी इज एब्सोल्युटली राइट. Which of the following statement is true in relation to the law of torts? Duty under tort is fixed by law. Duty under tort is not fixed by the parties. Duty under tort is towards the whole world. इनमें से कौन सा statement सही है? Which statement do you think is correct? Yes, I'm waiting. The correct answer is all of the above. All the statements are correct. Under tort the duty is fixed by law not by the parties. कॉन्ट्रैक्ट में होता है कि ड्यूटी और राइट्स पार्टीज ही फिक्स करते हैं, राइट? टॉर्ट में तो लॉ ही फिक्स करता है, और ड्यूटी इन रेम होती है, इट इज अगेंस्ट द होल वर्ल्ड. यस, दी इज एब्सोल्युटली राइट, वेरी गुड. Question number 19. Violation of a legal right with or without damage gives rise to a tort. डैमेज हुआ नहीं हुआ, अगर राइट वायलेट हो गया तो आपको डैमेज मिलेगा. यू हैव गिवन राइज टू अ tortious liability. RF establishes a salon and charges rupees 500 as a haircut. RF's neighbor Bhanvi establishes another salon and charges rupees 100 as a haircut, thereby creating a competition. This forces A to reduce his fee to 200. RF filed a suit for damages against Bhanvi. Decide. Pretty simple. Right, so Arif will succeed as Bhanvi's action caused Arif a heavy loss. Arif will succeed as Bhanvi violated his right. Arif will not succeed as Bhanvi does not violate Arif's legal right. Will not succeed as she reduces the price on his own. As he reduces the price on his own. What do you think? Pretty straightforward, yes. C. Arif will not succeed by keeping the prices or whatever prices she wants. It's completely her own volition. तो वो अपने मन से कुछ भी प्राइस सेट कर सकती है, और इससे किसी और को अगर नुकसान भी हो रहा है तो वो नुकसान कितना भी बड़ा क्यों ना हो, लीगल वायलेशन नहीं होगा, राइट? सो देयर इज नो tortious liability. Let's see. Moving on. A libel is a publication of a false and defamatory statement tending to injure the reputation of another person without lawful justification or excuse, where slander is a false and defamatory statement by spoken words or gestures tending to injure the reputation of another. So libel is a written form of defamation, whereas slander is a spoken form of defamation. So Manish wrote a letter to Pankaj calling him a cheat and a man of low morale. Sumit, Pankaj's clerk, opened the letter as he normally did, a fact which was known to Manish, and placed it on Pankaj's table. Pankaj alleges that Manish has committed libel. Do you think he has committed libel? Facts. Pankaj will not succeed as everyone knew that Pankaj was a cheat. Pankaj will not succeed as Manish did not publish the content of the letter elsewhere. Pankaj will succeed as Manish has published a defamatory statement against Pankaj. What? Okay. Pankaj will not succeed as Manish did not speak the defamatory statement. So, what do you think it is? Anyone? Yes, it is C. It is defamation. किसी और ने पढ़ लिया है वो defamatory statement, तो defamation हो जाएगा. C is absolutely right. Very good. Question 21. When the plaintiff voluntarily undertakes a risk to rescue somebody from an imminent danger created by the wrongful act of the defendant cannot set up the defense of voluntary non-fit injuria against the plaintiff. ध्यान से पढ़ लो इसे. When plaintiff voluntarily undertakes a risk to rescue someone from an imminent danger created by the wrongful act of the defendant cannot set up the defense of voluntary non-fit injuria against the plaintiff. Ronak left a two-horse van unattended in a street. Eric saw the runaway horses coming down the street. Seeing a grave danger to a woman and children, Eric took the risk and managed to stop the horses. But in the process, he was seriously injured. Eric filed a suit against Ronak for damages. Decide. Anyone? It is C. Ronak will be liable क्योंकि rescue cases voluntary non-fit injuria के रूल से में नहीं आते. ठीक है, rescue cases voluntary non-fit injuria का exception है. There's sort of exemption, like you cannot claim the defense of voluntary non-fit injuria if it is a rescue case, because आपने ही वो situation क्रिएट की है जहां पे रेस्क्यू ऑपरेशन की जरूरत पड़ गई है, तो आप ये डिफेंस नहीं ले सकेंगे. C is correct. Very good. The rule of strict liability was laid down in which of the case? Rylance versus Fletcher, MC Mehta versus Union of India, Donoghue versus Stevenson, Scott versus Lunnon and Saint Catherine Docks Company. Exactly, it's A. Of course, very easy. राइलेंस वर्सेस फ्लेचर में स्ट्रिक्ट लाइबिलिटी के रूल को ले किया गया था, राइट। उसके बाद फिर एमसी मेहता वर्सेस यूनियन ऑफ इंडिया 1986 व्हिच वाज द ओलियम गैस लीक केस। ओके, ओलियम गैस लीक केस 1986 में हुआ था। एमसी मेहता के कुछ और भी केसेस हैं उन्हीं के नाम पे। उससे इस केस के बाद सुप्रीम कोर्ट ऑफ इंडिया ने एब्सोल्यूट लाइबिलिटी के कंसेप्ट को क्रिएट किया। ओके, B. A is absolutely correct. Now, moving on, question 23. When one person signifies his willingness to do or to abstain from doing anything with a view to obtaining the assent of that other to such act or abstinence, he is said to make a very easy. He is said to make a proposal. Yes, it's B. Very good. Yes, it's B. अगर एक आदमी सिग्निफाई करता है अपनी विलिंगनेस कुछ करने की या कुछ ना करने की, इस व्यू के साथ या फिर इस एक्सपेक्टेशन के साथ कि सामने से वो मेरे ऑफर को एक्सेप्ट कर लेगा, तो इस एक्ट को हम प्रपोजल कहते हैं, राइट। दिस इज द फर्स्ट स्टेज ऑफ agreement or a contract actually. Proposal, acceptance becomes a promise is an agreement if enforceable by law becomes a contract, right? This is how it goes. This is the sequence. B is correct, proposal होता है ये। With respect to vicarious liability of the state under law of torts, the state can claim immunity in which of the following functions: administration, maintenance of law and order, defense of the country। मतलब इनमें से कौन सा फैक्टर है जिसके बेसिस पे स्टेट इम्यूनिटी क्लेम कर सकता है। मतलब इनको करने के दौरान अगर कोई रॉन्गफुल एक्ट हो जाता है तो स्टेट को पनिश नहीं किया जाएगा, उसको इम्यूनिटी है। तो इनमें से कौन सा है वो डिफेंस जो कि स्टेट ले सकता है? Administration of justice, maintenance of law and order, or defense of the country? Anyone? It is D. Very good. Yes. सब में ले सकता है। Administration, maintenance of law and order, and defense of the country. Very good, Vaishnavi. And was held in Nagendra Rao versus State of AP in 1994. The Supreme Court held that state cannot claim any immunity except while performing these functions. What are the functions? Administration of justice, maintenance of law and order, defense of the country, and repression of crime. सिर्फ 4 फैक्टर्स हैं जहाँ पे स्टेट कह सकता है कि हम लाइबल नहीं हैं। इसके अलावा कोई भी और फंक्शन करते हुए किसी का भी लीगल राइट अगर वायलेट हो जाता है तो स्टेट लाइबल है। ओके, और ये नागेंद्र राव वर्सेस स्टेट ऑफ एपी में कहा गया था। क्वेश्चन नंबर 25. A master is liable for the acts committed by his servant in the course of employment. Romila opened a savings bank account with Bank X, and a cousin of her by name John, who was a clerk in that bank, helped her to complete the formalities. Subsequently, she used to entrust whatever money she was getting to John. One day, Romila discovered that John misappropriated the money. Am I audible to you people? I'm not even sure. Internet is not working. If I'm audible, let's do this question. Bank X shall be liable because John was acting in the course of employment. Bank X shall not be liable because Romila was negligent. Shall not be liable because John was not acting in the course of employment. Shall be liable because John is its employee. And the correct answer is C. He's not liable because Romila or John was not basically acting in the course of employment. So it saves him from the liability. It's perfect. Oh, okay, thank God. right? So let's move on. Question number 26. An agreement made without consideration is void unless it is expressed in writing and registered under the law for the time being in force for the registration of documents and is made on account of natural love and affection between parties standing in a near relation to each other. Rohan promised his son Mohan that he'll give Mohan a bike on his 21st birthday. When Mohan turned 21, he asked for the bike as promised. Rohan refused, stating that he'll give him a bike after he turns 25. Aggrieved by the same, Mohan filed a suit for specific performance. Decide. क्या लगता है? पढ़ लो. He is a bank employee but he is not acting under the course of employment. वो जॉन को पकड़ा दे रही है, फैक्ट्स ये नहीं बता रहे कि वो बैंक में जाके पकड़ा रही है. तो अगर वो बैंक के बाहर पैसा ले रहा है तो वो बैंक के लिए पैसा नहीं ले रहा. जब तक वो बैंक में बैठ के अपने ऑफिस में बैठ के कैश नहीं लेता तब तक उस पर किसी तरह की कोई लाइबिलिटी नहीं आएगी. बैंक के ऊपर कोई लाइबिलिटी नहीं आएगी. ठीक है. मोहन विल नॉट सक्सीड, द अग्रीमेंट इज वॉइड. हाँ, कंसिडरेशन है नहीं, राइट, कंसिडरेशन नहीं है. और अगर कंसिडरेशन है भी, मतलब अगर एग्जाम्पशन को भी मान लिया जाए कि भाई कंसिडरेशन की जरूरत नहीं है, लव एंड अफेक्शन का ये बात है, तो भी अग्रीमेंट वॉइड होगा क्योंकि उसे रजिस्टर नहीं किया गया. इट इज एन ओरल प्रॉमिस. So without consideration, the agreement needs to be written and registered. Otherwise, it does not work. Right? C सही है. Question number 27. A proposal, when accepted, becomes a. I already told you the answer to this. I told you the sequence. And I want to see how many of you answered correctly. Okay, so Kanishk says it's B. Yash also says it's B. Anybody else wants to give it a try? Mariam, how about it? Everybody B. Vaishnavi also B. A proposal, when accepted, becomes a promise. A. I told you. मैंने अभी बताया है. If a proposal becomes accepted, it is a promise. Every promise is an agreement. If an agreement is enforceable by law, it becomes a contract. That's how it goes. Okay? It's A. Do not forget it. Question number 28. The communication of a proposal is complete when it comes to the knowledge of the person to whom it is made. It comes to the knowledge of a person who makes it. It is put in the course of transmission, none of the above. Proposal का communication कब complete होता है? When it comes to. Yes, you said B. तुमने B बोला था, तुम्हारा सही कैसे है? It comes to the knowledge of a person to whom it is made. You're saying it's A. Who else? Neha also says it's A. How about the other people? It is A. Yes. It is A. Except communication of proposal तब complete हो जाता है जब proposal की knowledge प्रपोजी के पास पहुंच जाती है. जिसको प्रपोजल दिया गया है, जैसे ही उस तक ये बात पहुंच जाती है कि हाँ मेरे पास एक ऑफर है, ऑफर का कम्युनिकेशन कंप्लीट मान लिया जाता है. ठीक है. फॉर द पर्पस ऑफ इंडियन कॉन्ट्रैक्ट एक्ट, कंसिडरेशन कैसी होनी चाहिए? रियल, एडिक्वेट, इल्यूजरी, बोथ ए एंड बी. बोथ ए एंड बी. Illusory is something that only exists in your head. Okay, so Yash says it's A, Amul and Kanishk says it's both A and B. Vaishnavi also says it's A. Indian Contract Act कंसिडरेशन की एडिक्वेसी पे कोई कमेंट नहीं करता. कंसिडरेशन रियल होना चाहिए. ए इज करेक्ट. अगर कंसिडरेशन एडिक्वेट नहीं भी है तो आप पे अनड्यू इन्फ्लुएंस का चार्ज आ सकता है, या आपको हो सकता है ये प्रूव करना पड़ जाए कि अनड्यू इन्फ्लुएंस का एलिमेंट इन्वॉल्व नहीं था। अदरवाइज कंसिडरेशन कितना भी हो चलेगा। अगर 10 करोड़ की जमीन 1 रुपए में बेच दी है तो आप कर सकते हैं, और वो कॉन्ट्रैक्ट भी वैलिड होगा हर तरह से, लेकिन वो रियल होनी चाहिए। ए इज करेक्ट, इट्स नॉट डी, इट्स ए। वेरी गुड। Last question for today: which of the following defines the term res is ipsa loquitur? Act of God, thing speaks for itself. He who acts by or through another acts for himself without any notice being taken. I'm waiting. The correct answer is, are you sure? Bikran. Vaishnavi says it's C, Bikran or Bikran says it's B. Who else? Nobody else wants to answer? बस दो आंसर, दो ही आंसर दे रहे हैं. Kanishk says it's C. How about Yash and Amulya? What do you guys think? It is B. Things speak for itself. Res ipsa loquitur means जब सिचुएशन इतनी विविड हो कि देख के ही समझ आ जाए क्या हुआ होगा, जहां पे प्लेंटिफ को कुछ प्रूव ही ना करना पड़े। जैसे पेट में दर्द है, पता चला कि एक मेटल रह गया है, पेट में एक मेटल है या रिंग है, 2-3 दिन पहले ही सर्जरी होके चुकी थी, तो इससे ज्यादा वैलिडली कुछ कंक्लूड नहीं किया जा सकेगा कि सर्जन की नेग्लिजेंस की वजह से कोई ज्वेलरी पेट में रह गई, क्योंकि अभी अब्डोमिनल कैविटी को 2-1 दिन पहले खोला गया था। ठीक है, उसको रेस इप्सा लोकेटर कहते हैं, रेस इप्सा लोकेटर, विच मीन्स when the situation is vivid in itself that nothing needs to be proven, you can just see it and gather the conclusion. Right, so that's it for today, guys. I hope you enjoyed and learned something from this session. These are all questions that might be asked, they have been asked once before. इसी बेसिस पर या इसी प्रेमाइस पर आप अपने क्वेश्चंस को प्रैक्टिस कर लीजिए। लीगल MH-CET का बहुत डिफिकल्ट नहीं होता है। अगर आपकी नॉलेज अच्छी है, आपकी प्रैक्टिस अच्छी है, तो आप इसमें 100% भी स्कोर कर सकते हैं। इट इज़ द लॉजिक दैट चेंजेस द गेम, सो बी प्रिपेयर्ड विद दैट, एंड आई शैल सी यू अगेन टुमारो एट 4 PM। तब तक सब अपना ख्याल रखेंगे और हम कल मिलेंगे 4 बजे। बाय बाय एवरीवन, थैंक यू सो मच।